Good morning, everyone, and welcome to the Wednesday morning seminar. Today we're joined by Mohammed Haque, who's going to be talking to us now about leave site now and don't come back, the joys of termination. So as always, if you would like to ask Mo a question, please feel free to use the Q&A or the chat toolbar in the bottom toolbar there to ask him any questions that you that come to you as we go through the session. And Mohammed will do his best to answer these at the end for you. As always, if there's something you don't wish to ask him in an open forum, please feel free to use his email address, which you can see on screen there, mohammed.haque@fletcherday.co.uk. He's always happy to answer questions offline for you. Without any further ado, Mohammed, I'll leave it up to you now.
Morning, and thanks, Julie, and welcome everyone who's joined us in this morning session of what is essentially we're to discuss today is the termination in construction contract. Of course, there's a catchy kind of title, leave site and don't come back again, which means an instruction from the employer. It could very well be I'm leaving site and not going to come back, from the contractor side as well. But anyways, this is what has been chosen. I will, in the next hour or so, go through with you what is termination and what are the different possibilities available at common law or in statutes, or by express terms of the contracts. And of course, I will take as an example one of the model forms, how that has been dealt with in the model form. So first of all, of course, to introduce, if you are familiar with it, which I doubt, but what is termination? If a contract is made, the choices then are that it's fully performed, which is of course a rare case, or it's been on some part, for some part been performed, for some part non-performed or misperformed. That means there is a breach. Then it could be that an event occurs which frustrates the contract, meaning it discharges the parties to the contract from any further liability to perform. Or the last option is the contract is brought to an end. And that's what's popularly known in contract law as a termination of a contract, and construction contract being a contract is no exception. This is just bringing a construction contract to an end. What are the possible ways? I'm not saying this is an exhaustive list. It could be a termination simpliciter. That means like you're getting married with a clause in there into your marriage declaration, that either party can go away anytime they want to, without any responsibility to the other by giving a notice. Sometimes notice is always a common practice in a situation like this, and not be responsible for anything or be responsible for the things they have done so far. So that's one way of doing it or dealing with it, making it sure at the very beginning that although it's a contract, either party can go away. It's just like if you kind of think of a lease where there is a break clause, and it just requires a notice. That's it. So parties go away from each other. Same is very common in employment contract, but I would say it's not so common in construction contracts. The second one is, though there wasn't any agreement at the time the contract was entered into, but the parties, for some reason or other, decided not to continue anymore, and they're in a position to agree in another contract what the consequence is going to be, how they're going to bring the existing contract to an end, and what the consequences for both parties going to be, all these terms and conditions. So that's termination or bringing a contract to an end by agreement. Again, not so common a thing. Now, due to a breach, of course, one of the parties to the contract may have done some default and not perform, either misperform or not perform at all, or say that if off, I'm not going to perform the rest of the obligations. So do whatever you want to do. I've had enough of you, that sort of thing. And sometimes, like as I've seen, construction contract is a very kind of creates a very emotional bond between employers and contractors, which is one of the biggest problems on earth, I think, because both of them at least pretend or continue to act as if they love each other, and that creates a lot of problem because they don't look at things seriously. So soon they find that either of them find that what they have contracted for is not possible. So they what else can they do? It could be the employer that not paying money anymore because he doesn't have the money, or it could be the contractor, he's not been able to perform because things are not in the same way as he thought it would be. And then say fall into that breach, not deliberate or intentional or in other sense constrained, but a breach is a breach. And if the breach is a breach for which termination is available as the remedy to the other side, the innocent party, then of course through once the breach of the one party, the aggrieved party, or the innocent party, or the party who is victimized, can take the opportunity to terminate, but he needs to follow certain procedures. And as I said, first of all, the breach has to be serious enough to be termed as a breach for which the right to terminate is there. If nothing has been said, then of course, whether the breach is serious enough can be ascertained from common law or from with the reference from some statute. So we'll see later on what I mean by that. And of course, it's not uncommon quite frequently to add express terms regarding termination. When can you terminate? What do you need to do when you are terminating? And I will discuss, as I said at the end, one example of a model form, how they have been dealing. I could have discussed many others, but I'm sorry, because due to time constraint, I won't be able to do that. But if you have any queries about other model forms, please feel free, be it any CIC, IKME, please feel free to come back to me. I'll try my level best to give you the answers. Now, it continues the slide, termination, what is it? Of course, I will focus first on the termination through breach of a defaulting party, and when does it happen, what is it, and what are the consequences of a breach, and all these. I'll focus on that first, and then the other ones like the agreed, which is a much better option. What happens if that route is taken? I'll do that later on. So what is it where it's a breach? Of course, it's understandable that not every breach or every trivial breach of every single terms of the contract are treated as a terminable breach. That's common sense, you know. However, that's common sense if the contract is silent, as you'll see later on. Of course, it's end of the day a contract, and who are we or the society to objectively determine whether a particular breach is so serious or not, you know. But supposing that nothing can be found from the express terms of the contract, historically we have the classification of contractual terms in English law between conditions and warranties. This clause warranty is, please don't be confused with the collateral warranties and guarantees type. This warranty simply means a minor term as opposed to a major term, if I can or may attach this terminology with or to this distinction, that One type, and how do we define it? As we'll see later on, the best way to define a fundamental term or a condition precedent is simply a term. That's, I think, the best definition for this purpose is a term, a simple breach of which will allow the aggrieved party or the innocent party to treat himself or herself as discharged, and can elect either to bring the contract to an end, or in other words, terminate. Sometimes the word rescind is used, or repudiate, in its good sense, not in a bad sense. Okay, so any breach of a particular type of term, let's say a terminable term, okay, is going to be enough for the aggrieved party to decide to terminate. Okay, every one of these things should be examined carefully, because even though there is a breach like that, it doesn't necessarily mean that you have to terminate. You are the victim. If you decide, well, I will enjoy the rape, let it be. But that's your choice. At least it gives you a choice to terminate. And the next question would, of course, be, how do we know that if in a contract a particular term is a fundamental term or a condition precedent, as opposed to a minor term, breach of which will not automatically become the breach which will allow the other party to terminate. So in other words, we need to classify between condition and warranties, or terms that allows the victim to terminate, and terms that they do not. There's nothing in terminology, because at times it has been said that it has to be a fundamental term. On other occasion, it has been said that there's nothing in a contract with a fundamental term. So don't fall into the trap. Just let's have a working list that these type of terms, if we can find these, and the performer is in breach, it becomes terminable. That's it for these purposes. There may be other purposes for which you explain these sort of things, but for this purpose, we will just look at it from a working method perspective. This route. Now, there is another thing, though, that also the term is not of its own from the very beginning a condition. It could be a sufficiently serious breach of a minor term may become a repudiatory breach as well. So the degree of the breach is another thing which you'll have to keep in our mind. So we just put some examples first. That, for example, in construction contract, the owner needs to confer the possession. And possession is a question of title to the contractor, so that the contractor can carry on. So, for instance, if the owner is a lessee of a lease, and the construction contract is about interior decoration, for example, or some refurbishment work to be carried out on a building, I'm at the moment dealing with a delay claim against a major corporate body, international corporate body, who wanted to build a lounge in an international airport for their customers, distinguished business class, first class customers. They wanted to build a lounge. Now, they appointed the contractor, and before closing the lease, an exclusive possession of the area on which they will be built, or they were supposed to build the lounge. Now it's completed. And then after signing the contract, they promised in anticipation that within a couple of weeks they'll be closing the lease, but for some reason or other, it didn't happen. And it continued. And as such, they couldn't provide the site to the contractor. And if you are familiar with construction contract, you will see the contract particulars and contract data and other terms of the contract are always referring to the date of the possession, because the entire concept, the contract period, starts running from the date of handing over the possession. And then there is a date of completion. Now, as soon as you fail to give the possession, meaning the title, to enable the work to be carried out lawfully or sufficiently, you are in default. And what happens? The contractor needs to mobilize on the day the contract says that you have to start the work on site. And if the employer fails to hand over the possession, and 9 times of 10 it happens, for one reason or the other. So you'll see that with model forms, they allow the deferment. Doesn't mean that if there is a delay, there won't be any damages, but it allows the deferment so that, it's a classic example, so that a breach is already covered. And just because there is a delay in handing over the possession, it will not automatically becomes a default for which the contractor can terminate the contract. Okay, so that's one example. And of course, the degree of the breach has to be sufficiently severe if it's not a condition, or even if it's a condition, then it has to be sufficiently severe and not merely temporary failure on his part to provide information or possession. But in all cases, the other thing is that even if you have said, okay, the slightest of the breach is a breach of condition and will allow the aggrieved party to terminate it, by looking at the contract as a whole, it could be decided that there are other terms which shows that this type of a breach was not to be treated as a breach of a condition. Just the example as I've given, you're saying that it remains in a sense to the contract or performance of this contract that the site is handed over on the day it's stated into the contract particulars or contract data. Yet there is another clause which says that employer is entitled to, in his discretion, to defer the possession for so many weeks or so many days. So these two, if taken together, it means that the employer can elect to defer it. So although it's important, but it's not that important that will allow the contractor, if there is a delay of a few days, to treat himself a discharge and terminate the contract. So that's something, don't get excited that, oh, this is the clause. I know I can just terminate this. I will not go there. What the hell are they doing? It's not such an easy thing. And termination is a very serious thing. So before the law would declare that you were allowed to, you'll have to cross a lot of hurdle. So just because there are bits and pieces and indications that there is a breach, which apparently is terminable under the contract, or even it's said expressly so, it doesn't mean, so the sufficiency and the degree of a breach, that's the thing, will be taken into consideration. Of course, the term which you have breached will be taken into consideration. And finally, and most importantly, the entire contract will be taken into consideration. If there are any other terms which actually negates the effect of the express termination clause, most likely that the aid of that term will be taken and will be declared that this was not a terminable breach. Continue to say that, well, if a breach is a repudiatory breach, or a breach which is sufficiently serious, or a breach of a sufficiently serious term, or a breach in a term which says into the contract that this will allow the victim to terminate, is a terminable breach, or in other words, it's sometimes popularly known as a repudiatory breach. And I will continue to discuss some more examples in the context of construction contracts, so that if you are somebody dealing with construction contracts on a daily basis, you will be able to spot them within your contract. A clear unjustified order not to complete the work is a repudiation. This is the title, you know, even if after 30%, 40%, 50%, even after practical completion, if the if the employer says to the contractor that I don't want you, you know, which sometimes happens, or many a times I've seen happens in residential projects where emotion plays more than in commercial contracts or in civils construction contracts, because it just is something that the architect, the contractor, the client or the owner of the project, they get together, they get very friendly, they want to achieve together a beautiful outcome, and then something happens, a minor thing, the color of the wall or something like in the bathroom. Say, if you are building a house, minimum, let's say a detached house will be at least a couple of £100,000, if not £400,000-500,000. And if there is a problem in the bathroom, for example, you see already there are molds, so you don't like the paint, or it's the shower is not working. What are these? You know, even if the cause is not a minor one, actually the system was wrongly installed. Pressure of the shower is not coming, and all these. You know, it can be replaced and it can be resolved in by spending few thousands. You know, and in few days, it's not a big deal really. It's not that like the wrong steel has been used in the structure, which will cause the building to fall sooner than later. It's not like that, but it becomes like so important sometimes to the parties, to the users, to the owners, that they think, no, I'm not going to allow this nonsense to continue, and I allow him to paint the rest of the house. And I declare, when the house is almost 80%, 90% complete, I would say, go away, you know, no, we don't want to see your face again. Please do not do that, because don't be emotional. Try to understand in terms of the totality of the project, and where does the breach sit, the ratio which is affecting you, and all these. And more importantly, forget about the law. The most complex thing is, as soon as you enter into a construction contract, you get some officious bystander who do not have anything better to do. They come and try to say that he has a contractor who would have performed better. All the time you'll see they're saying this. This guy doesn't know properly, he's delaying things, he's not working properly. And also sometimes construction is something like you do a part and then you allow a time, and you would feel as an owner, if it's your first time, that possibly they're not doing anything. And all of a sudden you'll see that a lot of things are done together. That's because that's how construction is done. So you might feel, no, this guy is not performing at all. He's not, speeding it up properly, and get frustrated, and then just take a decision. But the problem is, a half-done construction project, if you bring on someone else, they make your life a hell. They will start saying that everything has been done wrongly, and you have to redo it, and you'll end up paying more money, and then you go back and seek damages from the earlier contractor, and he justifies that no, he did as per your instruction, spec, and all these things, so there wasn't much of a breach, and you just get into a big trouble. So no matter at what stage, even after practical completion stage, when you're waiting for the defects to be revealed, unfolded, to be rectified, if you say this, they go away, you're ugly, it might cause you problem in the sense that some practical problems, for legal problems, that if you are telling him not to, then even though it's rather a trivial misperformance from the contractor, for which you did it, you may be decided as wrongly repudiating the contract or wrongly terminating the contract, for which you may have to pay damages. So that's one thing to keep in mind. Termination is a serious business. Don't take it easily. Then another thing is engagement of another contract, meaning, to execute the same works already let out to the contractor. So you give one contractor the whole package, and then there is some delay. Quite frequently it happens, and happened in my life as a professional, that okay, the brickwork section is not yet complete, and a section by the side of the brickwork you need some drainage work, and that's a drainage work you couldn't start, but you've already committed to somebody to do that drainage, and they're complaining. So you just said, when are you going to do this brickwork? And the contractor is saying, I'll do it at my pace and at a time slot I like. Who are you to tell me when do I do it? And then you just thought, okay, you have to do something because the other contractor will not be able to start working on the drainage package till this brickwork is complete. And you just assign somebody at the advice of someone to do that brickwork, which was actually part of the obligation of another contractor. That's a mistake. Don't do this, because if you're an employer, it may be that you will be treated as doing a terminable breach and a repudiatory breach, which will entitle the contractor to walk out of the site. Not that always they want to, but it could be that they do, because they have a better job, or they think this job is too complex, so they might take it as an excuse. Now, failure to pay, the historical position in UK is the failure to pay is not a repudiatory breach unless the contract says so clearly. So that has been the case for construction contract as well. That's common law, that just because the employer failed to pay one, two, or more, and actually at common law there is no entitlement to receive installments even, or part payment or interim payment of in construction contracts. So it's been historically the position that even after 70-80% the job is completed, the owner would have the chance to say that go away and don't come back, and the contractor will only have a right to recover damages under the contract. So that's draconian. That's not a very good thing. So we all know that Housing Ground Regeneration Construction Act of 1996, apart from creating the remedy of adjudication, it actually has created a payment mechanism or a payment regime, which allows almost for all construction contracts, if it's a relevant construction contract, almost all construction contracts are relevant construction contracts, unless it's very tiny, entitlement to the contractor to receive installment payments, either as agreed or as, if not agreed, on a monthly cycle. So that piece of legislation also provided that if the employer fails to pay on due date on 2 occasions, then the contractor has a right to suspend its operation. And if the suspension continues, then the contractor has the right to terminate the contract. So that's kind of a new innovation. I've referred to a breach being made repudiatory through a statute, earlier referred to it. This is a classic example that's in England and Welsh applicable. And if the employer fails to pay, the consequences are there. But if it's not a construction contract governed by HGCRA 1996, then still is the case that unless expressly agreed, a default by the employer in paying the money is not actually a repudiatory breach in English law. More examples: a failure to pay is less likely. I've already discussed this. Now, due diligence. We we know that the contractors in construction contracts expressly and impliedly are required normally to or usually to perform diligently. In other words, negligence in performing the contract in a timely manner normally is an express term. And if the contractor is found not acting reasonably as another prudent and reasonable contractor, then that's a breach. So it's a breach which, in the historical sense of English contract law, not construction contract law, contract law should give an impression that that should allow failure to complete the things duly and diligently or progressing it duly and diligently, so that it can be manifested or it can be seen that it will be finished timely manner. If that the contractor is in breach, then from the general perspective of English contract law, one might argue that this failure is fatal, and this is going to be treated as a terminable breach. That not necessarily be so in construction contract. Why? Because there is also provision of, no matter how seriously you state that you have to follow the dates diligently, that will be an essence of the contract. Any failure will allow the employer to terminate. Again, if there are provisions for the architect who's managing or the contract administrator or project manager who's managing the contract to extend and revise the date of completion, and an application has been made and a decision has been given, then that means really that breach is not so serious, which makes it a terminable breach. So again, from your general understanding of English contract law, if you approach a construction contract and say, okay, that says clearly that it can be terminated, that may not be so because of existence of so many other clauses, liquidated damages clauses, the existence of extension of time clause, the existence of a procedure which allows the architect to decide it, decide an application of extension of time, the clauses which describe the loss and expense. All these, no matter who says you that you have an option to terminate, please be hesitant and look at those things. If those are in existence, it is difficult to for breaches to decide that this is a terminable breach. Now, however, in the absence of express indications such as of the essence warning completion to time by the contract date of that date is extended, I'm not just cover it already, so yeah, no more. Repudiatory breach of fundamental term, I will continue to provide examples just as I've been doing. That it's another time where there are you are in the defect liability period. Apparently people think that, I can't terminate this, or he can't terminate this anymore. No, the employer can terminate if there are defects which has been shown, and the employer, following the contract terms, asks the contractor to rectify those defects, and the contractor fails to take any step, so that's something, or saying that no, it's not a sufficient defect yet, I'm not responsible. So he's just taking excuses. So then the employer has the right to issue a notice that fair enough, I will do the rest myself. One of the problems for the contractors, please do remember that in the light of the recent decisions of the English High Court and the Court of Appeal, that if so happens, and also that's in JCT anyway, if a contract is brought to an end due to a breach like this, in that case, there is not going to be a final account possible. So you will only receive a reasonable sum as a post termination final account or or evaluation. It's no more a final account, evaluation of the works you have done so far. So be cautious about that, because that might bring you into a different scenario than what you're anticipating. Because if you could remedy or rectify the issues, and do not think that it's a snagging matter, which there's got no legal basis. Snagging, let's say it's a minor breach, it's manageable. Do not take that so easily. Rather, take prompt action so that the employer doesn't, after you have completed everything, terminate the contract. So the one I've discussed or referred to earlier, other types of breach, though apparently seems not so serious, but if it's a repeated breach. So it's not the term we are talking about, which the contractor or the employer is in breach, and it applies even at common law where installment payments are agreed through contract, that if the employer keeps on defaulting the payments, and which is so serious in the sense that it continued and made it clear that the employer is not going to pay at all the rest of the money, then that breach is a sufficiently serious breach. Not an easy case to present, but still. Similarly, if the contractor keeps on delaying things, do not listen to the instruction of the architect, the contract administrator, or the project manager if it's an NEC, no matter how trivial these are, like small breaches of different terms or the same terms happening again and again and again, it might result into a breach to be classified as a fundamental breach, or a breach of a serious nature, which allows the aggrieved party to terminate the contract. Now, if, of course, the one party to the contract says that I'm not going to perform, do whatever you want to do, at any point of time, that's a repudiatory breach. No matter if it's 10% of the work is left or 50%. Sometimes I see, I act as an adjudicator quite frequently. I see that Hong Kong Fair Shipping Company, Kawasaki case and Kaisa are good in front of me, that only 10% is left out. How could this breach be so serious? No, it's not that. The point is that you, contracting party, deliberately made it clear that you're not going to perform the rest of it. And that's always treated in English law as a sufficient breach, or sufficiently serious breach, which is to be classified as repudiatory and will entitle the aggrieved party to treat himself as discharged and not to be liable to you any further. Now, then I discussed it a bit, but I will just re-explain a bit more, that where the parties indicated expressly by the contractual language that a single breach of a particular contractual obligation is to have the same consequence as a breach of a fundamental nature. I mean, if this has been made very, very clear, that if this breach occurs, if the windows are not of a particular type, then in its first attempt of installation, if it doesn't pass a particular rating or a particular type, then or a standard or whatever, then the employer will have the right to terminate it. In normal cases, it may not be a very difficult thing. Windows can be replaced very easily. In terms of a total building project, it's maybe very small, but then, well, if the front door is not of whatever spec or the sourcing or the type has been described, then I'll have the right to terminate it without any further notice. Can't help. It's been made clear to you, you're a businessman, a contractor, so that's it. But again, do remember that if there are other terms, as I was explaining, that time is an essence to the performance of contracts, as historically English common law position, and if you fall foul of it, the other party with a trivial breach has the right to do, but the extension of time clauses, the liquidated damages clauses, and a grant of extension of time and provision to for loss and expenses within the contract actually indicates that this is not the case. Similarly, if there are some other clause which negates this particular effect of the particular express language, that I can terminate if this thing happens, fine, then it may not be classified. So it's not so easy sometimes, Same is like the concepts of historical concepts of conditions precedent, essence of the contract. Use of these words may mean that this is a sufficiently serious term which allows the victim or the aggrieved party or innocent party of a breach to treat him or herself as discharged and classify the breach as a repudiatory breach and bring contract to an end. However, it may not be sufficient. The contract as a whole will be considered. Now, of course, the concept of affirmation. Please do remember that just because there is a breach, it doesn't mean that it's automatically treated as terminated. Okay, no contract is automatically treated as terminated just because there is the breach of a fundamental term or a repudiatory breach or breach of a minor term repeatedly, which allows the aggrieved party to repudiate. It doesn't automatically make the contract terminated. The aggrieved party must either elect to terminate, accept your repudiatory breach and elect to terminate, or they have the option to affirm that, fair enough, there is a breach, I will still continue. And do not also forget that the repudiatory breach or a breach which entitles a party to the contract to terminate the contract is a breach of a condition, which means for this purposes that although the aggrieved party affirmed and continued and sought the performance of the contract by the other party, he still has the right to claim damages. So even if you say, okay, I'm not happy, but I'll still allow you to continue with your contract performance, it's not the end of the world. The aggrieved party, and which I would say is a more reasonable approach, aggrieved party will still hold the right to seek damages for any breaches if he or she suffers one. Also, always remember, it's not an opportunity to earn some profit. It is a legal right to get some compensation to bring you on board, just as you would have had the facilities you would have had if the contract was performed properly. So that's the ground rule. Now, if you are the aggrieved party, be prompt in making your decision or the choice that you want to terminate or you want to affirm and continue. If it's from all the facts and circumstances of any particular breach in a case, if it's the conclusion that you haven't decided to terminate, then you'll be treated as have affirmed the breach and decided to continue. So in other words, you'll not have the right to terminate the contract anymore. So you need clear act to set your position up. Don't be very dubious, and then think, oh, now I can terminate. You might then have already lost it, you know. But obviously, the other side, who's in default, he cannot claim that no, the breach has been affirmed because they have allowed me to continue. The breach has occurred allegedly, let's say, in July, and this is October. Still, I've been doing things on site and there was no complaint. It could very well be that the problem never came out. You've done something, you've kind of closed the chapter, a foundation work, a brick work, a wall being constructed, and there is a mistake inside. So it's very normal that even if things have been taken back, if you're in breach, you're in breach. So don't think that this would be a defense of affirmation in your hand, that the other side has affirmed and allowed me to continue. No, the question of the knowledge of the breach is very vital, so as only when he gets the knowledge of the breach and the facts of the breach, and then decided to choose, okay, I will either continue or terminate. And then if the aggrieved party decided and continued, you have a defense. Other than that, no. Well, affirmation could be expressed or implied. Yes, it's not, doesn't have to be ceremoniously declared that by whatsoever means and whatever has happened, I, such and such, is declaring that regardless of the effect, serious breach and this, I have decided to put my mercy on you and you are allowed to continue. It's not like that. But obviously you can put that in writing, in a letter, you can put that in email, that fair enough, John or Richard or whatever. I'm not very happy, but still we have decided to continue with you, and please perform it properly. That will be good enough. Or, as I said, if it has been discussed, it has come to the knowledge of the aggrieved party that there is a breach, if the solution has been discussed and nothing has been done to terminate, then that could be by conduct and implied affirmation, and the victim will lose the right to terminate. So it's possible, not that always it has to be expressed, it could be implied as well. And again, it's if there is a repudiatory breach, and if there is a clear and unequivocal acceptance when it's been claimed by the defaulting party that he has accepted. So if there is a clear and unequivocal one, just because nothing has been done for a period of time, it will not allow you to take a chance. Okay, so if you are in repudiatory breach, make sure that you try to resolve the matter promptly. Do not leave it, okay, let's take a chance. Don't sort of mention this, it might become a problem for us to continue. Don't take that approach. Open it up, discuss it with the other side, and try to find a resolution. That would be much better than trying sort of hiding and giving some knowledge. And if the other party was delaying, then saying, you have not decided promptly, so your right is gone. Don't take the approach, you might lose. Well, both parties are alleged to have committed a breach of contract, and it's asserted that each breach taken independently gives right to terminate further performance of the contract. Regard must be had to the order in which the breaches occurred. So this is a common sense brings time order. Earlier, the one breach is earlier, will be allowing the other party to terminate, the order in which it has been terminated, and order of performance as well. Say, for example, if a particular thing, an employer needs to issue some free goods and he failed to issue that, and so that caused a delay, which is categorized as a repudiatory breach, then of course employer's failure, although it's not been said that somewhere that his failure is fatal in his right to terminate, it comes as a matter of logic automatically. So time order of performance, time order of termination, and time order, not only time order, the logic order of performance or order of performance, that if one performance is dependent on another, and if the first one has not been performed by the party one and the party two automatically defaulted, then it cannot be taken as a repudiatory breach. Well, effects of termination: it will release the innocent party from all further performance of his obligations and entitle him or her to damages, including loss of contract resulting from the termination. So if you are an employer, if you have to redo it with or do it with a third-party contractor, whatever amount you have spent less the amount you would have paid to the first contractor is your loss, and any loss of use, if there is a delay in completion, charged in the market rate of rental, will be your loss. If you are if you're the contractor, you have lost to perform the contract, and the loss of profit is your measure damage. Now, effects of termination: rights acquired before discharge. Although both parties are discharged from further performance of the contract, rights are not divested of discharge which have already been unconditionally acquired. It's common sense again. What has been done in the past is past. And sometimes the provisions of dispute resolution, it's clearly written that it continues after the termination as well. And if it's a termination by an express term, the contract says what to happen. Termination clause in standard forms. As I said, I will take the example of one standard form, which is JCT. It first says that you have to give the notice of termination not unreasonably or vexatiously. So it's just letting us know that it's a serious thing. Just because you feel that I want to terminate, do not use it as a tool. Okay, just because your ulterior motive to express, harass, or annoy, you are frustrated emotionally, it's not a good cause to issue a termination notice. And it's clear that this express reservation of any other rights or remedies preserves the normal rights at common law of such party against the other. So what I'm trying to say here is, just because there is a termination clause in the standard form, do not think you have lost your right under the common law. It still could be, you may try, if that's not a termination under the standard form, it doesn't exclude the common law unless it says so clearly. So you can still try your common law rights to terminate, though you have a termination clause within your contract. And if these allows you to just bring things to an end, as I said, these are construed very strictly. And if there are other clauses which says that it is, although allowing you to terminate, but by construing the whole contract, it's not, that will be the most preferred way of interpretation. And last two things to remember: if you are doing it under a standard form like JCT, each notice, you have a notice requirement, each notice is a timing, and there is a procedure, and the contract says what do you need to include within the notice. So each of these things will be very, very, very vital to finally decide whether you have terminated properly or not. Even if you have a proper right to terminate, if you miss one of these, it could be that your termination is wrongful. This is something most of the time people forget. So please take note of that as well. And that's where I finish. If you have any questions now.
Okay, thank you for that, Mohammed. We don't appear to have any questions at the moment, so that's great. I would point out that we are back with Mohammed this evening at 6 o'clock. He's single-handedly almost keeping the seminar ship afloat at the moment, covering some other people, other presenters. But we're back with Mo this evening, 6 o'clock, for how to get through ADR and keep your cash. which should be an interesting session. So if you'd like to book on for that, please email us at seminars@fletcherday.co.uk. And then tomorrow we have John Sharp, who's presenting the first in the construction and insurance case law roundups. So interesting cases that have occurred over the last 12 months directly impacting either construction contracts or insurance law. So please feel free to tune in for that. We have got one question here, Mo. Someone's asking, what example of rights would not be divested or discharged in termination?
Well, I mean, the ones which you have acquired earlier, that's the simplest of all. For example, if there is a payment which was due already, you have done the job and you are in English contract law, you have made an application and the due dates were over and you didn't, the final date of payment is over as well. So for all purposes, the contractor is entitled to money. Now, it's you cannot feel yourself that you are discharged just because the contract has come to an end. You know, one example, there are many. Anything that has been accrued under the contract, okay, although terminated, but if it has already fallen due under the program of the contract, then that's it. You know, you'll be responsible fully for that, even after the contract is terminated. And that's applicable for both the parties.
Okay, that's great. If anyone else has any other questions, either in relation to that or anything else, please don't hesitate. As we said earlier, if you do have something you don't wish to ask in an open forum, please feel free to email mohammed.haque@fletcherday.co.uk and he will happily answer these questions for you. Okay, that seems to be all for now. So thank you very much, Mo. As always, we'll see you again this evening for the ADR and Keep Your Cash. And everyone enjoy your Wednesday. It looks like the weather's fairly decent today. So everyone have a great day and we will see you all either tonight or again soon. Take care.
Bye.